Welcome to Sovereign Citizen Legal Encounters. Hello, everyone that's already in the chat, and for the people that's been waiting. And then I come into the chat and I see we have a new member. And this person joined early today. I kind of took a peek. I said, oh, okay. So, Cheryl Stewart, welcome, welcome, welcome. All right, just once again, we'll say hi to everyone out there. Okay, we see this is someone I know personally. Thanks for stopping in and checking me out tonight. And for everyone else that normally come through. All right, Brian, I like your comment. Huh? You under duress tonight? That's how you feel? All right. All right. So we have Buckner that we're gonna be looking at tonight. All his hearings in Simpson's court because he was in court yesterday and got his final verdict. Some of you may have seen it, some of you may not. But if you did and you back here again, I appreciate you to watch it again. All right. Oh, there you go, Aqua Queen. How you doing tonight? All right, so we're gonna get into this video and we're gonna have some fun like we always do. Okay, let's go.
State your name.
Lawrence Buckner.
All right, go ahead, counsel. Mr. Johnson, go ahead.
Good morning, man. Please, this Honorable Court, Kareem Johnson, appearing on behalf of Mr. Buckner.
All right, what are we doing on this case?
Yeah, I have received all discovery and police reports with body camera. We're asking this matter be set for exam. However, Mr. Buckner has, I believe, 3 witnesses that I think we will want to ask the court to take testimony from at the exam. So I'm asking for some extra time to make sure I can get those witnesses subpoenaed to court.
Any objection to that, counsel?
Joe, I don't object to the outbreak saying or to defense counsel's request. However, I believe counsel is new on the case. He's not aware of something that comprised the public defender of. Earlier this week, this defendant made threats to witness a preliminary examination. A new charge has,
Sir, you need to face me.
a new charge has been authorized against this defendant as a result of his conduct. And as a result of that new charge being authorized, we are requesting remand. We have previously advised the public defender's office.
Judge Graham Washington is in the office.
Your Honor.
Your Honor, this is,
Sir, I will give you an opportunity to address the court, but you're not going to interrupt any. You're not going to interrupt anybody. You're interrupted. Yes.
This exam was held on Tuesday, and after the victim in the case had testified, Mr. Buckner, during a break in the exam, threatened her in the gallery, and we did end up charging him with threatening to injure a witness. And this is a victim that he was not supposed to have contact with, as she was a victim on the FA case. So in that sense, he had violated the bond by contacting her in court and also threatening her with criminal charges, which is why we asked you for his bond.
Sir, what did you want to tell me?
sir.
Well, Mr. Buckner, I'd advise at this point you don't make any statements.
Mr. Johnson, I need to speak because if I don't speak, if the prosecutor said they want to lock me up in remand, it's up to Judge Simpson. So I have to present my portion of the truth. If I don't, I'm going to tell. Like, I have a family to support. Please, like, I am not guilty. And this is what I,
Well,
okay, okay, on Tuesday, I had a hearing for a situation that I was accused of, right? During that hearing, it is my belief, so let me just say that, it is my belief that the coerced witness messed up the testimony. So they said that the witness said that I threatened her. I never threatened her. They said that they went to the officers, they had stuff on body cam, sir. No, it wasn't that. If you go on body cam, I was talking to my aunt Sandra Lamont and my family member, my phone was going, and I was talking to them, and nothing out of my mouth said, I'm gonna threaten that lady, I'm gonna get that lady. They have been trying to harass me and my family ever since that I got shot on Father's Day, and I didn't cooperate with the police investigation. I got shot 9 times, 1 time in the head. 2 days before all these incidents happened, please hear me out. Deputy Caruso from Washington County kept coming to my house saying, you need to testify who shot you. You need to testify who shot you. I said, Mr. Caruso, all I want to do is live my life. I got a family. I got my brothers here. I got people that I support. I don't want nobody getting killed. I died twice in my brother's arm. The next day, I got in an incident with my lady friend, and it went from a domestic violence to stalking. Ypsilanti police officer Tyson came in to Washington County Jail. The very night I was arrested, tried to read me a personal protection order. I said, I don't want to do it, and I didn't do anything wrong. The next day I woke up, I had stalking charge. That was dismissed. That was malicious prosecution is going on. Please hear me out. Then Jacob Dillon came to my house, tried to run me over with a vehicle. I punched his window out. I go to jail for that at my home. Okay. Then so I come to court, and the prosecutors, Judge Lawrence Washington is the eyewitness. This same prosecutor, while we was in court on camera yesterday, sir, while we was on court on camera, just please hear me, said Mr. Buckner is threatening my witnesses in court. This is what this same prosecutor said. Judge Lawrence Washington said, no, he's not. Mr. Buckner is talking to me, and he's not threatening. See, that already had it out.
Stop. There was a video requested. Does the video show anything?
Yeah, I haven't had a chance to review it. I just got it this morning. But we were informed immediately after the threat occurred. I and she informed our advocate, and then informed us that it had happened. And then she did a police report, and then we authorized the charges.
Yana, may I?
Hey, just a second, Mr. Johnson. Has the complaint's been authorized? Has it been sworn to?
I don't think so yet. It was just authorized this morning at 8 a.m.
All right. Yes, Mr. Johnson, go ahead, sir.
Yana, this was not my case. This was the public defender's office's case. My case was dismissed prior to this case on Tuesday. I have no knowledge of this. I have no discovery on this. So I can't effectively address this and make sure my client gets his due process rights in terms of a bond revocation hearing. I understand that this may have just happened Tuesday and all the police reports and video camera have not been gathered. But I do think it is unfair to address this right now. Mr. Buckner has always showed up to court. He's always showed up to court timely. I think it's best for the attorney who was present at that hearing to handle this bond violation, especially if that case is still ongoing. I just can't effectively represent Mr. Buckner on a bond violation that I did not know was going to occur this morning right now, Yana.
Oh, just to let you know, the caption on there is from the court, because sometimes they'll do that. I think if it's somebody that can't really hear or something and they may be watching it, so they'll put that up on Zoom.
Yeah. Mr. Brown, were you there on that?
I was not, Mr. Michael. First of all, I was not there. Mr. Michael Gaddy was. I'm not sure is this being handled as a bond violation.
Well, they're asking for revocation of this bond because of new charges, I presume.
Did y'all notice all the people that's standing behind him like he's some kind of celebrity or something? It's like all the deputies are back there. A lot of the people in the front row of the court, they're all standing up. It's crazy.
And the nature of those new charges. So that's what they're asking for. I think a couple of things. And I don't know what there was a request made for video from this courtroom of that day. We got time narrowed down. You need to take your hands out of your pockets. And the request was made. I checked with Judge Washington because she was the judge presiding as to whether or not she had any objection to that. She did not. That was, I think, Byrne provided to the people in this case. They have not had an opportunity to review it.
So as it stands now, these allegations that they have violated nothing's charged.
Well, no, it's basically charged. It's authorized at this point. It's just it hasn't come through. the system yet. Okay, so here's what I'm going to suggest, and it may not like it, but I think maybe this is the way to do it. The video. Somebody from your office, Mr. Brown, was handling his exam, correct?
Yeah, that's funny, William. I like that.
Okay.
We just talked about it.
He didn't see anything. So what I would do, and I get Mr. Johnson's point, he's trying to do that. What I'm going to do is temporarily take the defendant into custody. I want that video provided to Mr. Buckner. Mr. Buckner. I don't know what's on the video. I did not view it myself. And then have counsel look at the video, and then I will myself look at it. We're going to break to be able to do so, and then make a determination if based upon that, his bond in this case should be revoked. I think that's probably the fairest way that I can potentially do. Yes, sir.
Sir, I appreciate you first and foremost for this opportunity. And I say just to the court that upon looking at the video, the prosecutor said that I want the whole court to hear it. I physically said that I was going to threaten and get this woman.
Sir, first of all, I don't want you saying anything about what's going to be that new case coming up. I don't want you saying anything. I'm not going to hear it because you're going to end up hurting yourself. What I have said is you will be going into custody. We will then, and I'm not saying even at this point I'm going to keep you in custody. A video was requested. I'm going to give the prosecutor got to look at it. I'm going to give counsel that was handling it at that time an opportunity to look at it also. Mr. Brown has already indicated they spoke with your attorney at that hearing and he did not witness anything. And I don't know because I was not the judge presiding. So this is the best that I can do to try to figure it out at least preliminarily.
Mr. Judge Simpson, I'm a very honorable person. I'm asking in all respect. I'm not a flight risk, sir.
Sir, I'm not saying that you are.
My dog's in the car. Is there any way that I can call my brother so he can come?
Sir, I'm going to expedite it as best I can to make sure that I can look at it, get you recalled back up, and tell you what I'm going to do. But I think everybody has to look at it. Mr. Johnson's not here, so he can't himself look at it, but it affects his case. But the people that can look at it can do that and maybe get in touch with Mr. Johnson.
I was thinking the same thing, Tim. And the thing is, she's all the way up in the camera on it. So I don't understand that.
No, but I'm just saying that's the way I'm going to handle it at this juncture. All right?
You don't represent me. Okay. So the guy that represents me is Mr. Gotti. Mr. Gotti is the key factor that you being here.
Okay, look, Mr. Buckner, they'll be able to talk to you back there. But I'll pass the matter. Sir, you need to just quiet down, please.
Okay, he passed the matter. Now the matter is about to come back. Here we go.
This is Lawrence Buckner.
Joseph McMillan, people, Your Honor.
All right.
See how empty that courtroom is now?
Mr. Johnson, you're muted. Sir. Go ahead.
May it please the court, Kareem Johnson, appearing on behalf of Mr. Buckner.
All right.
What about that? They're anticipating the acquitted. We're doing arraignment.
Yes, I'm going to do the arraignment. And just to bring you up to date, Mr. Johnson, the new case that we were talking about has actually been, I now have the file and I'm going to conduct the arraignment on that charge. So, all right. I don't know if you were informed of that. All right. Your name, sir?
Sir, my name is Lawrence Buckner Jr.
All right. You are before
See how he didn't play that family name Buckner this time?
the court on a felony complaint, a one-count felony complaint that alleges that on or about April 1st, 2025, at the location of 4133 Washington Avenue, that being the 14A District Court, that you did influence or attempt to influence the testimony at an official proceeding by threatening to kill or injure a person. It's commonly known as witness intimidation, committing a crime threatening to kill or injure. Not asking you, sir, whether or not you believe you did that offense. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony. It is punishable by up to 15 years incarceration and or a $25,000 fine plus court costs. Do you understand that? You understand that, sir?
Yes, sir.
And you understand also, sir, that a consecutive sentence may be imposed for any other conviction. You understand that? Mr. Buckner, you can sit down while we go through this.
All right, sir. I didn't know. I'm sorry.
Did you understand that, sir? That a consecutive sentence may be imposed for any other conviction.
Sir, forgive me for my emotional upbringing. I don't know what to say right now, sir, and I truly apologize to the court. I don't know what to say yet.
Well, I just need to make sure that you understand and can answer the questions that I'm asking. I need to make sure of two things primarily. First of all, that you understand what you charged with. You told me that you do understand that. The other thing that I need for you to understand is what the maximum penalties are. You may want to mute that.
I'm so this is my life. This is my freedom just snatched from me, and I was understanding this son where I came with that. Y'all just talk to me. See, I told you I got shot in the head, so you're not hearing the wrong thing. Okay? And you said it wrong. Video, but now you tell me no video. That's what I'm not understanding, because the whole basis of my freedom today was Judge Simpson in the video, and that's why I need help.
Judge Simpson's had enough. That's why he's sitting back in that chair. And for those of you who watch him, you already know what's going on. But I'm going to give you a little tidbit real quick. So he acts this way in Judge Simpson's court with the sympathy. He did the same thing in Magistrate Braley's court. He did the same thing in Magistrate Garwood's court. But when he gets to Judge Washington's court, he's a totally different person. I've been watching enough of his hearings to see it. So he only acts like that over there.
Oh, what charge is this? This is the charge of having April 4th in Judge Washington court? Okay. Potentially. I understand the potential. I just, from the time, I apologize for the sentence. I'm a little slow right now, so I apologize to the court ahead of time. Y'all be further ahead of me. Second to original charge. Second to original charge. Ms. Johnson, Ms. Washington, one of Yeah. I understand, Judge. I'm sorry. I don't.
Okay, so you understand the maximum penalties on that charge?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney on this? It's a public defender case.
Thank you.
As to the formal reading, you waive any further formal reading of the complaint, stand in. All right. All right. Defendant pleading not guilty, demanding a probable cause hearing. Court will enter that plea. Set a probable cause hearing, and Mr. Johnson, before I set that date, were you asking for an adjournment of the other case? You were asking for that to be set for exam, were you not?
I was, Your Honor, but based on these new developments, I think.
Stay in jail. I'm not trying to stay in jail, Mr. Johnson. Like, please help me. I'm not trying to stay in jail.
I will.
Like, I don't want you to tell the judge to adjourn something. And then I need to be heard on it and find out I did nothing wrong. I need help. And helping me is not leaving me inside watching our county jail or trying to put me on some type of crazy bond. Like,
Your Honor,
I need help.
okay, Mr. Buckner, Your Honor, based on my client's representations, I still ask that the court set this matter for exam. As I indicated this morning on my case, Mr. Buckner has, I believe, 2 or 3 witnesses that we would like to try and call at exam. I need some time to subpoena those witnesses. So I was asking the court for an extra week.
So if we were setting the 15th, you would be looking at, say, the 22nd, you're saying?
Yes, sir, Your Honor.
All right. Any objection to that from the people on case ending in 1120?
No, you're saying that for 20 seconds, not.
All right. It's to bond in this case.
The allegation here is that my client allegedly had some outbursts and witness. I had a chance to look at what was available on the equipment that was done. I'm looking at weakness and strongness. Charge with destruction is weakness. That means that he was trying to prevent this witness from coming to court, testifying, trying to change what this witness has. All of it goes to whether that witness would be able to appear in future court. Taking the best of what we've heard of the prosecution. Saying you've been lying on me. Ms. Evans, my client, is not saying he said that. But what the prosecution says that you've been lying on me, she killed you or something to that effect. She shoots you or kills you. Yeah. Notion is for threatening intimidation is that he has to be doing something to prevent this witness saying, don't come to court, trying to stop this witness. I think even if we hold her to this allegation based on her, I don't think the prosecution should be able to take out a case that his intent was to try to prevent this witness from showing up, coming to court, intimidating this witness from saying, testifying truthfully. That's the necessary. Because I do not believe that he will be successful in getting conviction, I'm asking that the court set for my client a personal recognizance bond. And here's the reasons why a personal recognizance bond. You have the ability to have no contact. It has a home in Ypsilanti, 680 box. It's not having anything to do with money witness lives. He's self-employed, he raises dogs to sustain himself. He suffers from numerous bad living networks already being raised and he's been shot a lot of times. So he's got health problems that arise with that. Finally, he lives with his autistic needs he has to take care of. He also has a brother who can help him make sure that he returns to all future workmates. It's a responsible individual that should.
I think the charge here is a strong charge. I think it's a charge that even taken in the light most favorable to the prosecution, they will be able to prove that you probably caused that.
Thank you. Response.
Thank you, Your Honor. In this case, as in many things, context is key. This exam is on first this Tuesday. At that time, the victim testified at exam. The defendant pointed a gun and racked at while she was working as a security guard. It was after this that the defendant asked her to go to the bathroom. While walking out, threatened her in the gallery. She immediately reported this to the victim advocate and the assistant prosecuting attorney. Specifically, this defendant said, "You're lying, a lying fucking bitch, I'm going to get you." This is right after she testified being threatened with a firearm by this defendant.
I was trying to hold off on pausing because it's hard to understand a little bit, but it's funny because when they're whispering up there, you can hear everything, and then Judge Simpson tells them they have to back away from the mic. But when they talking normal, sometimes you can't hear it. But I also wanted to acknowledge Rob, 1 month of membership. Congratulations, I appreciate it. Honestly, it seemed like you've been here longer than that. And when I saw that pop up, I was like, "Oh, you've been talking on here for a while." So I really appreciate that.
Based upon this defendant's conduct, under people believe that a $100.
Oh, I had one other person, Dragonfly. Yeah, you asked, was Judge Washington's video available? Yes, it is. So I'm planning on doing it tomorrow. Before the end of this live, I'll probably do a poll and see if y'all want me to do it live tomorrow night, or I could just post it up.
$1,000 bond, no 10% is appropriate in this case. This was very clearly an attempt by this defendant to intimidate this witness with regards to the case at District Court at exam. The condition of the bond in that case, case number 5-121. I'm sorry, I may have misread that case number, was that he had no contact with the victim, and here he is in court threatening this victim. This is not taking place in a vacuum. This defendant has a pending misdemeanor domestic violence case, the FA case that was the subject of the exam involving firearm, and malicious destruction of property felony case. Based upon this conduct, based upon his extensive criminal history, they frankly have extreme concerns for public safety and victim safety. We're asking that as a condition of the bond in this case, they have no contact with the victim in Hudson, have a no-go to order as for a residential place of employment. And frankly, Your Honor, is this defendant's conduct which has brought us to this point. And the fact that this threat was uttered during the court meeting immediately after the testimony of the victim is gravely concerning to people, and to our mind points to a need to set a significant bond to secure the safety of the public and of the state.
So I'm going to respond, Your Honor.
Yes, sir.
Obviously, very clearly means something different to the prosecution that they describe it as an angry outburst. It doesn't rise to showing any intent to keep anyone doing anything except that angry outburst. They went big head and tried to charge a witness intimidation. It's not that the person already testified, said she was lying, was angry, it was an angry outburst. But we're not going to try this. We're here to show the prosecution is that things that the court takes into consideration is the likelihood of conviction. I think the likelihood of conviction is, as the prosecution says very clearly, I think that's the case at all. And what you have is not angry outburst that's being spun, something based on what they saw in context, an unproven charge.
But if it were directed at the victim in that case, that irrespective of what's being said, that would be improper context, you'd agree.
That's right. It's a line with a separate case, and that's exactly what's going on. They can certainly say you shouldn't have said anything, you shouldn't have had an angry outburst. That's a bond violation. That's exactly that. In the context of whether or not they should be charging the case, and with this their discretion, if they decide context of whether or not they're likely to get a conviction based on that flimsy information they have there, that's not likely. So yes, maybe they can say it's a bond violation. They should be actually bringing a bond violation rather than charging an entire case. They can't complain to you and say, oh, no, you know, we got a new case based on that.
So there seems to be a misperception because the victim had testified at an exam that somehow this conduct was not supposed to be the victim. The victim's testimony would be needed at trial. And to make this statement, not only that he accused her of lying, but that he was going to get her. When this same victim has seen this defendant firearm at her and rack her weapons, clearly the intent here was to intimidate the witness in question. So based upon this defendant's conduct, I believe that $100,000 bond with no 10% is an appropriate remedy. As an additional condition, Your Honor, should this defendant be able to post gas or GPS tether, it will go conditions as to placement of employment residence to the victim. But very clearly, this defendant conduct was demonstrated with
I don't know that I have a name for the.
The name of the victim, Your Honor, is Amy Hudson. That's A-M-E-E. The first name, Hudson.
Say again.
A-M-E-E.
Okay.
Last name Hudson, H-U-D-S-O-N.
All right. Anything else, Mr.
No, the way it works is it's on a motion, and then you respond, and then you respond, and it's supposed to stop.
Well, I can actually run my courtroom any way I want, but that's okay. Thank you for the suggestion. I'm going to order standard conditions, including no assaultive behavior or any possession of any weapons or anything fashioned to be a weapon. There's to be no possession of any alcohol, recreational marijuana, or any illegal drug. I will order no contact with Amy Hudson. You're not to go to either direct or indirect or through third parties. I will also indicate that there's be no mention of Amy Hudson on any social media or any use of any type of social media. You're also not to go to that person's residence or employment.
Sorry, Joseph. I know it's hard to understand, so you want to come back in and probably look at it through the captions that way. His audio is just messed up sometimes. I try to do the best I can, but sometimes I can't get it to where I want it.
Or place of employment, I should say. What is concerning in this case is that if what is said, and I disagree with the defense, that there has to be something where they did that there. If said, if what is indicated was said, which oddly is consistent with, in some respects, with the underlying offense and what is said, which makes it even, I will have to say, more frightening if it was said. And that it is said during, even at a recess, but during a court proceeding where the defendant knows he is not to have any contact with that particular individual, is highly problematic and something this court cannot tolerate, should it be. That type of individual, in this court's mind, does pose a significant threat to the public in regard to his behavior. I would also indicate that I don't necessarily believe that the defendant is a flight risk, certainly, but I do believe that given everything that the court has heard, he is a significant danger, if not to the public in general, to this one individual. He may be a particular danger. The court is going to set the defendant's monetary amount of his bond at $75,000 cash sure. If the defendant is released, he is to be placed on the GPS home confinement tether. The court may allow, upon petition, his ability to go to work once that's established, but $75,000 on that case.
I'm surprised he didn't faint like he did when he was standing up.
Thank you.
It's possibly from the judge watching it. It's probably the same stuff that they charge me for right now. The same stuff that they charge me for right now. A prosecutor told Judge Washington that I was disrespecting and threatening her client inside of the jail, inside the courtroom. Judge Washington looked right at her and said, "No, you're not." He looked right at me. So I asked you to talk. Judge Washington could have helped me because they got me charged on. They got me charged, Judge. And so this thing, right? For me to make one statement, Judge Simpson, I'm charged with making a crime in the courtroom, right, sir?
Well, you're charged with intimidating a witness that may have taken place in the courtroom. So.
Okay, and sir, this is the time that I got arrested and you sent me back here. The thing that I was trying to work on you was, I mean, the community of people that was helping me, and I know everything I'm saying, but you already made a decision, is that the video inside Judge Washington's courtroom, a Wayne Washington courtroom, was the video that would have proved my innocence. The prosecutor told Judge Washington that I was threatening Amy Hudson while she was giving her testimony on the stand. Amy Hudson was on the stand. Wayne Washington stopped the court immediately and said, "No, he's not. He ain't looked at her. He ain't said to her. He's mumbling things to me, trying to get my attention." This is on camera in Grand Washington Court. So now, how do I help myself, Judge Simpson?
Your attorney will be able to get a video of that proceeding. All right, Mr. Buckner, thank you.
Hey, Mr. Brown, Mr. Brown.
Yes. Thank you.
No, I don't, but the conditions still.
Okay, we're moving on to the next hearing. Working our way up to the verdict. We getting there. All right, let's go.
Court calls the case People versus Lawrence Buckner.
That's one people.
Hey, thanks, Scott. I appreciate that. Let me see who else. Okay, all right, yeah. Peace out, Mr. Buckner. That's right, Brian. Here we go.
Defender on behalf of Mr. Buckner.
Your name, sir? All right.
Your Honor, so obviously we're here for a probable cause conference. I have a chance to speak with prosecutor Mr. Buckner. I think we'd like to set this matter for their examination. There's currently 2 separate April 20th for the accommodate that date.
April 20th?
22nd.
22nd. Who are those before?
Judge Washington.
Okay, the 22nd is the date I'd give in any event. Those are set already before.
Yeah,
Okay.
I know one is fine. The other one is Mr. Johnson's case.
They are.
I believe it's all the Johnson's.
They're both second with Washington. All right. People don't have any objection to that.
No, we'll try for that date, Your Honor.
All right. Preliminary examination in person, April 22nd, 2025, 9 a.m. before Judge Washington. You may.
Yeah, Mr. Buckner's here. He's not a flight risk in any way. Locally, I believe that the objectives of the court could be accomplished in terms of any violation or any kind of contact with any of the confirmed witnesses in these matters. Could be achieved through a tether or a hot zone or a tube zone. As I said, he's not a flight risk. He has a bond. I believe the bond in this matter is $75,000. In looking at it, I think there's a bond of remand in the MDOP case, which is not the case I'm representing him on. But I'm not quite sure if that's what's
There's two other cases. What do you have as this one? Because I don't have those before me, so.
if I don't. I need to address them about
Well,
case.
Mr. Buckner was going to try to say something, but I don't know if you want him to say anything, Mr. Betty.
Judge Simpson, last time I was in court, I came here in court, prosecution had brought up intimidated witness charge. You said that you were going to remand me back to Washington County Jail until you get that video to see if I actually threatened the witness.
Well, until, right, but let me just clarify that. I was going to look at it as to whether or not I was going to do a remand prior to the charges coming forward. The problem was the charges then came forward. And so I arraigned you on the charges. So there was a distinction in what I was doing at that point, but go ahead.
I was under the impression that once you look at the video and see that any criminal activity was done on my part, that you would reinstate my bond. My words, my videos, I didn't do anything. It's he say, she say. I wasn't on the video for being crime, sir.
Okay, so Mr. Buckner, just so you understand what I was doing. Remember at the time that you appeared here, and a flight risk is not my issue with Mr. Buckner at all, because he voluntarily came in and he cooperated with the court in every respect whatsoever. But at the point at which we were addressing it and it was brought up to the court, I did not have a complaint in the case. And so what I was doing, the people at that point were asking to have you remanded, defense counsel, and you were objecting to that. And at that point, I was going to make a decision as to whether or not I was going to remand with knowing that the charges may be coming. But I wanted to look at something because you were vehement in saying no, people, and I knew that there was this video there. Before I could even get to that, the charges came through. And so then at that point, you were arraigned on the charges themselves. So there was at least some determination, although minimal, that the actions occurred because the charges had come forward. Okay.
Judge Simpson, I would like to say in closing, I appreciate you. However, I was brought back up to see you at 3 p.m. One had informed me that you didn't get to watch the video, but you did.
I know. Okay, so we can go, Mr. Buckner, we can go through all of this. The problem is, it doesn't matter what the bond in this case is because he's denied on his other case.
Cyclist, to answer that question you put there, I think this is the guy that was supposed to have been with him on the last one. That's why Attorney Johnson wasn't able to help him, and maybe the other guy that was down there with him stepped in. That's what I'm thinking. I'm not really sure, but I know someone was supposed to deal with his bond and stuff.
So I'm not going to change everything. Let it all get before Judge Washington. She can determination of your bond. She can hear this argument of the bond in this case, as well as what's going to have to be your argument in the other case. Because I could change your bond in this one. It doesn't release you.
I'm talking about the $75,000 bond. I'm talking about the bond. I came to court for I was at the court for the gun charge, no, the NDOP case. They told me, it is what it is. Yahweh, God of the universe will vindicate me, and I'm thankful for all this time. Thank you for the time.
All right.
If we get to 2 weeks in jail, time to sit there. And, no weapon formed against you prosper. In these lies, I will be vindicated. I will be vindicated. And I hope I will be filing initial prosecution against Washington County for everything that they did to me since my shooting.
All right. So what I'm going to do is I'm going to deny, just so that we have a record of it, I'm going to deny your request. The reason I'm denying it is because he's held on the other matter. And then this exam will be set on the 22nd with all his other matters before Judge Washington. Bond will continue in this.
Thank you, Your Honor.
Thank you. Hey, Mr. Gardner, that's where the problem comes in. Just walk out quietly or go out quietly, please. I've been that for 60 some odd years. I get it.
All right, that was funny because he told him to walk out. I got a kick out of that. My voice a little under the night. Well, Mel, his original charges, Buckner has like destruction of property, I believe, something with a weapon. Then he has a telecommunications charge. He had an intimidation of a witness charge. He has stuff going on in both this court and Judge Washington's court. So I covered it on one of my other videos and list all of his charges there. But this guy has a lot going on, to answer your question. And Cyclist, you're welcome for what I sent you in the chat.
Versus Lawrence Buckner.
Oh, I should have mentioned. So this hearing was yesterday, and this hearing has the witness of the one that said that he intimidated this witness in the case. So you'll get to see some testimony in this one. I was just building everything up to this, so that way, if anybody didn't see it, y'all know how I do. I just try to put the whole thing. There were a little more, but this would have been way too long. I would have been able to get it from other courts, but we'll just focus on this one, and then we'll probably do Washington tomorrow.
On behalf of the people, Your Honor, I want to please the Honorable Court, Kareem Johnson, on behalf of Mr. Buckner, approaching and seated to my right.
State your name, sir. Thank you. All right. Date and time set for preliminary examination. You may proceed.
That's correct, Your Honor. The people are ready to proceed. We intend on calling one witness, and the people call their first witness.
You may.
We would call Amy Hudson to the stand.
See you on the phone again. See you on his phone. Because you did that at the. Pardon? Counsel approach, please. Yeah, have her sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? See, state, spell your first and last name for the record.
My name is Amy. It's A-M-E-E. My last name is Hudson. A-S-O.
All right, you may inquire.
Thank you, Your Honor. And just one other matter. My officer in charge, Deputy Von Heath, is present in the courtroom. He's the only other witness I have present. I don't intend to call him, but he is present.
All right, good.
Miss Hudson, directing your attention back to the date of April the 1st of this year, 2025, were you in this courthouse testifying in a preliminary examination on a different matter?
Yes.
Okay. And was that in this very courtroom, courtroom C?
Yes.
Okay. And who was the judge at the time?
Washington.
Judge Washington? Okay. And was the defendant in that case, based on your understanding, Ms. Hudson, Mr. Buckner?
Yes.
Is he present in the courtroom today?
Yes.
Can you identify an article of clothing that he's wearing?
He was wearing a black.
Okay. Your Honor, may the record reflect in-court identification of the defendant?
Without objection, record shall so reflect.
And I don't want to get into the facts of that case, but you were some sort of witness in that criminal case. Was that a criminal case?
Yes.
Okay. And you were a witness in it?
Yes.
Okay. And had you testified before Judge Washington in that matter on the date of April 1st, 2025?
Yes.
Okay. At some point, were you done testifying?
Yes.
Okay. After you were done testifying, what did you do?
I went and sat back down while they called up the next witness.
Okay. Where did you sit down?
I sat about where I was sitting when I stood up today, maybe one row up.
Okay. So we're making a transcription of this. So I'm going to have to
So
be.
it's on the right-hand side, probably the third row back.
You're pointing in the courtroom. So you remained in the courtroom?
Yes, I remained in.
Okay. So you sat down in what we would call the gallery of the courtroom from where you are sitting in the witness stand on the right-hand side. And you said about the third row back.
Third row back.
Okay. And you did that while another witness was testifying. Okay. And at some point in time, did that witness stop testifying?
Yes.
Okay. What happened after that witness stopped testifying?
The judge asked for some more information and then she called for a break.
Okay. The judge showed up to take a break? Okay. Is that a yes?
Yes.
Thank you.
I'm sorry.
It's okay. And what happened when the judge stood up to take a break?
When they called the court for recess, he was on the left-hand side.
Who is he?
Mr. Buckner was on the left-hand side. He stood up. He was around two people that had already started to be in the row.
I'm going to just stop you right there. So you've said the left-hand side. That would be the left-hand side of the courtroom from where you are seated in the witness stand today.
Yes.
Okay. That would be the side that the defendants normally sit at?
Yes.
Okay. Where was the defendant seated?
He was in the first row back.
In the gallery?
In the gallery.
Okay, so he was not seated at counsel table?
No.
Okay. So the judge got off the bench and exited the courtroom?
Yes.
Okay.
Yeah, the judge, she did not exit the courtroom right away. She stood up, as they were calling. There was two people up front talking to her. And then when she got done speaking to them, that's when they called the recess. And he stood up.
He being the defendant?
The defendant, yeah. Went towards the middle. There was two people already going to go to exit. He waited until the sound went out.
Okay, when you say how do you know he waited until the sound went out?
Because he turned around and he looked. He stopped.
Objection, speculation.
I'm gonna overrule the objection. I'm gonna let her.
He stopped. He looked back. The minute
Hold on. Look back at
the
where?
screen. He looked back at the screen to make sure that the judge.
I'm gonna just,
Okay.
I'll stop you there. We're gonna unpack this a little bit. And Judge, I understand the court's
Okay.
concern. So you observed the defendant. You said he stopped. Where did he physically stop?
In the middle.
In the middle aisle?
In the middle of the aisle.
Okay.
Yeah.
Where was he in the middle of the aisle, close to what we would call the bar or close to the back door of the court?
He was in the middle, like closer towards this side of
Your motion, the right side.
the right side.
Okay.
Yes.
But I'm asking you, distance wise, was he in this area or was he in the back part of the
No, he was closer towards the
front? Okay. You are still, fair to say, you are still seated in the third
I'm
row
still seated.
on the right, your right side of the courtroom.
Yes.
Okay. When the defendant stopped, is he looking at you or is he looking somewhere else?
When he first stopped, he was looking like straight ahead.
Straight ahead.
And then he
And
turned
Straight ahead toward.
Yeah,
towards the exit door.
towards the exit door.
Yes.
Okay.
And then when he stopped, he turned around and he looked
And in what direction, when he turns around and looks, in what direction is he looking?
He's looking to see if the judge is,
I'm not asking you. You can testify to things that you see, things that you hear, things that you witness. You can't testify to what someone else is thinking.
right.
Okay,
No, he
so,
turned in the direction as to where the judge stand is.
okay, so just so we're clear, the defendant was looking towards the back doors of the courtroom. He then turned around and is looking in the direction of where the bench and the TVs are.
Yes.
Okay.
Yeah, the bench and the TVs are.
At some point, does he then turn back around to look towards the back door?
Yes, he does.
When did he do that?
The minute the screen started making that sound.
Like a white noise sound?
Yes.
Okay.
Yeah, like
And
it's no longer.
And I will direct your attention right.
Okay, go ahead.
I'll direct your attention right now. There are screens on in this courtroom. You
Yes.
see those?
Yes.
And they're depicting the court and yourself in the witness stand. Is that correct?
Yes.
Okay. Did the screens look like that? Okay. What did they look like? If
They
you look?
were like, as if cable went out, they were, there was nothing there. It said private.
Okay. It said private.
There's a black screen with private written in white.
Yeah,
Okay.
yes.
At that point, once the screens changed from showing the video of the courtroom to this private, what did the defendant do?
He walked on to the right-hand side, stopped to where I was sitting and, made verbal threats.
Okay. He said something to you?
Yes.
What did he say to you?
He called me,
I'm going to stop you right there.
yes.
Hold on a moment. You mentioned something, and I just need to clarify this. You said that there was static.
Yes, sir.
What was that you're talking about?
There was no more pictures showing. It was just a like when you call up the lawyers to speak to you, the screen makes a noise. It makes it makes a noise. I don't know how to describe it. It's not it's not a silent noise. It makes a noise to where it's not recording anymore. Do you want me to sit down so you can turn it off?
No.
Okay.
Judge Simpson is totally confused, which should throw red flags up. Now, I never heard of anyone sitting in the audience. Well, I haven't been there, but he mutes it or puts it in private, and the audience hears all of this noise. I think they would have tried to fix that. But let's see.
I'm pretty much here every day. I'm just trying to figure out what you're talking about. You're saying it made a noise.
Yes, the screen went blank, and it's not like it's crushing out a noise. There's a noise
Coming out of the speakers.
Yes, coming out of the speakers.
Was it a constant noise?
It started, and then I'll be honest, I don't know if it was on.
Gotcha. Okay, just one other thing.
That's fine.
When you said Judge Washington was talking to two people, was she talking to two people in front of the bench or two
Yes.
people behind the bench?
No, two people in front.
So she was speaking to two people in front of the bench. All right. At the point at which she's doing that, can you hear that conversation?
No,
Okay, at the point at which she's doing that, do you hear anything in the courtroom?
no. I mean, I can hear people talk, but not up front. Like just what, people may be saying as they're sitting on the gallery.
Right, but do you hear anything else?
No,
Okay. And she had that conversation and then turned around and left.
yes, yep, they call.
At the point that that happened, what was on the screen?
Before we got done speaking to them,
Not as she's talking to them. What's on the screen?
there's nothing on the screen.
All
And
right.
then she got done speaking, and the video came back up before they called recess.
And when you say the video came back up, the video like it is right now?
Yes, And it
Okay.
just showed her on the bench. There was no one on the stand.
Okay, go ahead. So at some point, as we've discussed, the defendant then turns and is walking, now facing back towards the back door,
Yes.
which would also be in the direction that you are in relation to the defendant.
I think he's just recapping what she's saying, so I'll overrule it. Go ahead.
Yes.
Okay. And you had previously said the defendant said something to you.
Yes.
Okay. What did he say to you?
He called me a lying bitch and told me that that he was gonna be even, he was gonna get me. That was the last thing he did. He was gonna get me.
Did you say anything in response to that?
No.
How did that statement by the defendant make you feel?
Threatened.
After he made that statement to you, where did the defendant go?
He turned around, looked back one more time.
I'm going to stop you there, just so we're clear. So the time he's talking to you, is the defendant looking towards the back of the courtroom or the front of the courtroom?
He's looking towards, well, he's looking at me.
Right.
At the exit.
Okay, so he's facing away from where the judge would sit.
Yes.
Okay. After he makes that statement, you said he turns around?
Yes.
Okay. When he turns around, in what direction is he now facing?
He's facing back towards the front where the judge would be sitting
Okay.
in this area.
At the time he turns around, is the judge on the bench?
No.
Okay. If you recall, at the time he turns around, who would be on, and I'm motioning on the other side of the bar, who were there attorneys or people present?
Yes, yeah,
Okay.
his lawyer was still on the left-hand side. You guys were still on the right-hand side.
You guys being someone from the prosecutor's office?
Prosecuting,
Okay.
yes. And there was one officer also on the right-hand side, and there was one officer sitting out in the gallery, like 2 up from me.
Okay. So the defendant makes a statement to you. He turns around and he's now facing back in the direction of where the judge would sit. And what happens next?
The minute he saw that his lawyer was coming out, he turned around and took out the exit door.
Okay.
So again, speculation of what my client saw.
Okay. I would agree. So his lawyer, what you saw, ma'am, was his lawyer starting to leave and then he left.
Yeah. the minute he
That's
saw-
what you, no, that's what you saw.
Yes.
Okay, thank you. I think that corrects it. That's what. Go ahead.
And did you remain seated in the gallery of the courtroom or did you exit the courtroom at that point?
I remain seated.
Okay. And at some point after this fact, did you bring what had happened to someone else's attention?
Yes.
And who was
It
that?
was one of the police officers.
One of the police officers present in the courtroom?
Yes.
Okay. After you made contact with the police officer, did you have any further interactions with the defendant, Mr. Buckner? Okay. Certainly not in the courtroom,
Right.
correct?
Right.
Okay. Anything in the hallway of the courthouse?
No.
Okay.
No.
Mayor, one moment, Your Honor.
You may. While you do that, ma'am, you said you were seated in the third row. How far in on that third row were you?
Right there where the gentleman is with the black sweatshirt.
So you were seated on the end
Yes.
toward the aisle.
Yes.
Okay.
I have no further questions, Judge. Thank you.
All right. Cross-examination.
Okay, ma'am. So you were here to testify, and if you remember, was that in case number 25 FB 1106, if you know?
I have no idea.
Did you get a subpoena to come to court and testify in that
No.
case? In that case.
I did not get a subpoena.
Okay.
They asked me to come and testify.
Now, it's my understanding that you're indicating that you are
Picking
seated
him up. Picking him up.
in the gallery of the courtroom right here.
Wow. Okay. Yeah, gotcha.
Is that correct?
Yes.
And you said that there's a member of law enforcement 2 rows up, sitting right here, where there's an individual with a sheriff's shirt.
Yes.
And your testimony to Mr. Buckner comes down the hall, the aisleway, stands at that same pew where the law enforcement officer was, and issues a threat to you, which would have been within 15 feet of the law enforcement officer.
I never said that. I said he stopped at where I was sitting and said something to me. I never at any time said anything that he stopped where the police officer was sitting at the pew.
So when he stopped, he was at your row.
Yes,
But there was still a law enforcement officer 2 rows up.
yes.
Was there other law enforcement officers in the courtroom like there are today?
There's one sitting up in the corner, up here on the right-hand side, where the gentleman is with the glasses.
When any of, I'm sorry.
Sitting where?
The gentleman with the glasses over here?
Mr. Bird?
Yes, that's where the other.
Oh, on this side? On this side?
On this side.
On the right? Okay,
Yes.
go ahead. Go ahead, counsel.
When this statement was allegedly made, none of the law enforcement officers in the courtroom jumped up and said anything? Now, you indicated that after you testified, you stayed in the courtroom.
Yes.
Was there a sequestration order that, was there an order that you leave the courtroom after you finished testifying?
No.
Okay, so you heard the testimony after your testimony.
Yes.
Mr. Buckner's lawyer at the time challenged the accusations that you made regarding Mr. Buckner, correct?
In which case?
In the case you were there to testify about.
Okay. Your Honor, I would object to what that other lawyer did. That would be hearsay.
I'm not asking for
Well,
what,
she's asking, I'll overrule that. I mean, he's not asking what she said. He's just asking what her impression of what he did.
right.
So, go ahead.
His lawyer in the case you were there to testify on was challenging you on the assertions, allegations you made about Mr. Buckner.
For that case?
Yes.
Well, I mean, I don't know if he was challenging me, he was just questioning me the same as you are.
And there was another witness that came up to testify after your testimony, correct?
Yes,
You heard that witness's testimony.
yes,
You were there when the preliminary examination ended, correct?
yes.
Oh, I gotta stop for a minute. Okay, Mad Jack, 3 months. Congratulations. Celebrating that membership. Appreciate you hanging in there with me. And also, I didn't want to stop, but the Lego jokes, I've been trying not to laugh, but it's funny. And right after you did that, Mel, he went out there. I guess the attorney heard what you said, because he went out there and he was actually trying to figure out where she was at. So that was a good one, because I see the chat's been going off about that. I like that joke. They do need some Lego people or some dolls with a little courtroom, and then they can do it like that.
That Judge Washington found that there was no probable cause that Mr. Buckner committed a crime. Correct.
I would object to the relevance of that.
Well, Your Honor, the relevance is they've charged my client with intimidating.
I'm going to overrule the objection.
Yep.
Go ahead.
Judge Washington found that there was no probable cause to believe that Mr. Buckner committed a crime after you testified, correct?
She also stated that it can be called back up if they get the proof that they need.
Okay, which is fair. All right. So after you made accusations about Mr. Buckner pointing guns at people, correct?
What does that have to do with this case?
Ma'am, I don't.
Answer the question, ma'am.
Yes, I did.
You made accusations that you saw him deliver crack from a great distance away. You didn't make the accusation? Did you make an accusation that you saw him point a gun at somebody?
Yes.
Okay. No further questions, y'all.
I didn't hear anything about the crack question unless the mic went out, because I sure want to know the answer to that.
I have no redirect, Judge. Thank you.
All right. Ma'am, how long did it take you to report this to somebody?
Within minutes.
Where was Mr. Buckner when you reported this?
He had walked out of the courtroom.
How long after he walked out of the courtroom did you report it?
Within probably 2 minutes, if even that,
To whom?
to the police officer passing by.
Which police officer? Is that officer here today?
Yes,
Okay, and that's who you reported it to?
yes.
That interaction, and if you look back on the right-hand side where the gentleman seated in the black shirt is, you're saying that's where you were sitting.
Yes,
When Mr. Buckner came down the aisle, you'll notice that the back row is basically a handicap accessible row or a non-handicap accessible row. You see that where it extends out?
yes.
How close was Mr. Buckner to you when he's making these comments?
He was past where the gentleman is sitting with the black sweatshirt, and he was in between that row and the woman sitting right behind him. And he leaned back and
he leaned back.
He looked, turned his head back and spoke to me.
So because that's a little bit different than what you told me before, because you're saying that he was where the gentleman seated in the black
Right.
he was past him toward the door.
No, right, there's right where he's sitting, right there, at that spot, right there. It's like there's a spot, where you, not where you would enter, but where would be if you're standing beside. So closer towards the opening of the back row.
So he's standing closest to the opening of the back row.
Right, but he's beside where the gentleman is with the black sweatshirt. And that's right.
But he's over on that side of the courtroom?
Yes,
So ma'am, are you telling me he's no longer in the middle aisle?
no, he crossed from the middle aisle to stand closer towards the right-hand side. He's no longer in the middle. He's standing like as if you're having a one-on-one private conversation with somebody.
And how loud were these comments you say he was making?
They were not other people were walking out of the courtroom. I could hear them, and it's not like he was screaming them. They were normal voices.
Yeah, that's the same thing I was thinking, Mel, but they probably don't record all the time in there because I'm sure that video would have been part of this. So I don't think they record. They probably do their Zoom recordings. I'm assuming, but they probably do their Zoom recordings, but they probably don't record the courtroom all the time in real time is what I'm thinking.
When you testified in the previous matter, was there a victim's advocate assigned to you?
Yes, there was a victim's advocate.
Okay, so after you testified, did you talk to that victim's advocate?
No. They asked me to just go sit into the courtroom.
I want to go back, ma'am. At the time that you Sister Buckner got up, what's on the screens in the courtroom?
The screen was still on to where you could see where the judge was sitting. And then she called her a conference And then the screen went blank. And then the screen went back up to where you could see where the judge was sitting, and then she called for a recess.
And then what happened to the screen when she called for a recess?
And then the screen went blank and said, you know, right, it didn't show any pictures, didn't show any people anymore.
That's right. I'll put a poll in there because I want to know what y'all think about this because the story doesn't seem to be clear cut. On my bad, Avalanche, they only give me 2 options. Yes or no.
Prior to the judge taking recess, was it Mr. Buckner's other case that was being heard, case that you were there for?
That case had been heard, and then honestly, I know that case was heard, there was a witness, but I think he was sitting out in the galley, and I think that they had started to call for another case. Because I don't think that.
Had your case that you were there on, had it concluded at that point?
Yes, because he was sitting out in the galley.
Okay. So then my question is that case had concluded?
Yes.
The judge had made a ruling?
No, she had asked for some more information, and they had set it aside for a minute and was going to call it back up.
And so had they called another case?
Yes.
Was Mr. Buckner's attorney on that case?
No, he was sitting on the left side, where the gentleman is. He's behind his lawyer right now where the glass is.
So he had moved back to the chair.
Yes.
But during Mr. Buckner's case, he was at the table with Mr. Buckner.
Yes.
From that period in time, that case ending until the judge took a recess, approximately how much time was there?
Judge Simpson sitting back in that chair. Look at the look on his face right now. The look of frustration. And also, yeah, that was a good point, Denise. If he was talking in a normal voice, how does it that the police officer or deputy or whoever didn't hear him? I don't know. Because if he made a threat like that, I mean, we'll see what's going to happen with this.
Mr. Buckner, you said was in that first row, right?
Yes.
How far into that first row was he?
Like right on the end.
So he's right on the end, seated where I guess the young lady in the pink would be.
Yes. I'm sorry.
Sorry to use people as props, but that's where he was sitting?
Yes.
Okay, so he's sitting right behind his attorney.
Yes.
Okay. And then at some point he gets up
Yes.
and walks back. Were you the only witness that had testified in that previous case?
No, it was me and one police officer,
Okay.
but I was the only.
Where was the police officer that testified?
He was sitting over, on the right-hand side where the gentleman is with the glasses.
Did he testify before or after you?
After me,
He testified after you.
yes.
Was there another witness then?
They stopped because the judge asked for information. So they were pausing it to see if they could collect the information that was needed to proceed with the case.
So just so I'm clear, you were the first witness to testify, right?
Yes,
The next witness was a police officer.
yes,
And all during that time, Mr. Buckner is at the table where approximately where he is right now.
yes,
Then at some point, there's a break. Mr. Buckner leaves the table
yes.
and is seated in the first seat in the first row behind defense counsel.
Yes,
Then another case is called,
yes.
right? And was it the attorneys? Was it the attorneys on that next case? Was that who the judge was talking to?
Yes. I don't know if it was it was someone from the state and then someone representing that person. So yes, that's who the judge was talking to.
They were the attorneys on the next case.
Yes,
Okay, and the judge spoke with them.
yes.
As the judge is speaking with them, what do you hear in the courtroom?
The noise coming from the speaker and
What noise?
the, whatever that noise is. I don't know how to describe it.
Okay.
But just so we can hear what's being said up here at the bottom.
Okay, so you hear that.
Yes,
At the point that you hear that, where is Mr. Buckner?
still seated.
Okay. The judge then leaves that session, gets up to walk out.
Right, but the screens turned back. When they went back towards their tables, the screens went back to where you could see the judge. And then they called recess.
All right. At the point that they call recess, where is Mr. Buckner?
That's when he stands up, goes towards the middle of it, and then there's two people. He goes, and then that's when he stops. There's two people getting out like in the next row.
How many people were behind Mr. Buckner in the gala?
Honestly, I don't know.
How many people were in, was there a person sitting behind you?
I don't think so.
Was there a person next to you?
No.
Was there a person in front of you? Which would have been in the second aisle?
I don't. If there was, I think.
Didn't ask that. Do you know whether or not, okay, do you know whether there was a person 2 aisles up?
Yes.
Who was-
Police officer.
And how far over was the police officer? You're saying where the gentleman that just sat down in the blue tie would be? Mr. Warren
No,
Grant, that's you.
further over. He's probably where the other officer is, if not closer towards.
So he's further over toward the wall.
Yes.
Is there anybody else in that row that you recall?
No.
Is there any, so where you are, you're saying there's nobody in your row?
Not that I remember, but I'm not that I remember.
Behind you, you're indicating that there's nobody behind you in that row.
Not that I remember.
In front of you, the row would be directly in front of you. There's nobody in that row. that you recall?
Not in front of me, there was someone down.
There was what?
There was someone down closer towards like where the gentleman is with the blue tie. There was two people right there.
There were two people right there?
Yeah. They weren't towards the edge, they were like in the middle down.
This is totally confusing. Look at Judge Simpson, because it almost appears that nobody was really in the courtroom. She can't remember if anybody was on her row. Now, behind you, I get that. But in front of you, now the person is like way up ahead of you. I'm thinking, well, where was the police officer? Because I don't know if he's going to ask that or not. But this is what I'm thinking going back through this again.
When Mr. Buckner allegedly makes those comments, do they turn around?
I was not paying attention. I just put my head down and just let it.
And also, to me, it's just my opinion. Y'all can put it in the comments. But if you're in the court and you get threatened, that's the best place to get threatened, because you can stand up and tell somebody right away, especially when she said there were two officers in there. She could have got loud and said, hey, don't threaten me, because that's part of the case. And I think that happened either.
All right. Counsel approach briefly. All right, let's go get that first. So what I'm going to do in this case is, and I talked with counsel, I'm going to take a brief break, get some information, get it to counsel, and then continue the hearing after that.
May this witness be excused, or is the court obviously appropriate if the court wants to inquire based on reviewing the video?
Yeah, I don't want this witness excused at this point, because I may have questions, and the video also may give rise to questions from Mr. Johnson. All right. So we'll pause in this case. You may sit down, ma'am, and I'll call you back up. And court's going to take a brief recess. And I know people want to talk to me, but court's going to take. Yeah, but court take a brief recess.
All rise.
Okay, so Judge Simpson's brief recess, I think it was like an hour. I think he just had to take a break. And I see some things going on in the comments in reference to what y'all are probably thinking. But the story to me is kind of all over the place. And I think let me look back on the comments of, for kids rule. So you said if she's lying, yeah, what reason would she have? I don't even know the history with her and Buckner as to why he was supposed to have been intimidating her as a witness, or maybe whatever he did, because he has so many charges. But yeah, it's just a lot that goes on when Judge Simpson's making all of those faces and sitting back in his chair and trying to figure all of this stuff out. Something's not making sense here, but we're about to find out.
None of that was caught. All right. State of Michigan is Lawrence Buckner.
Andrew Childers appearing on behalf of the people, Your Honor.
Good afternoon, Kareem Johnson, on behalf of Mr. Buckner.
All right. We had finished that witness. Do people have a motion?
And I guess just for clarification, I don't think we technically finished the witness.
That's true.
So if the court is satisfied, I have no further questions for that witness.
Okay.
No further questions, Your Honor.
All right. Very good.
We'll have no further witnesses. The people will rest.
All right. Any witnesses for the defense?
No, Your Honor.
All right.
Your Honor, at this time, the people would move to bind the defendant or charge on the one count of witness intimidation based on the testimony of our one witness. Obviously, the court has provided both myself and Mr. Johnson copies of the video. Because our county issued laptops don't have CD discs, wasn't able to watch it myself, but I know the court has watched it, and I trust the court's judgment in reviewing and will respect the court's decision in that. And so, thank you.
All right. Your Honor, for the testimony, reasons stated on the record through cross-examination and the video that I asked to be admitted as defense exhibit A, I'd ask the court to not bind this matter over.
All right. The court will admit without objection exhibit A.
Now, I ended the poll. It was 50-50. 50% yes, 50% no. Let's check it out.
In this matter, the court was very specific in questioning Ms. Hudson with regard to where she was at particular times and the like, to try to get a sense and feeling as to where Mr. Buckner would have been at any given time. The long and short of it is, when I review the video, it is clear Mr. Buckner is not seated in the first seat. He's actually seated in the second row back. And he's sitting there. We can pick up Mr. Buckner, and I'm looking at it. When I time what portions of the video, well,
That is on me. It got cut, so I'm gonna finish it because it's right at the end. So this is what happened. And sorry about that. I think when I put the video together, it must have separated. But anyway, so they looked at a recording, and during the time that she said the screen went private, Buckner was nowhere near her, and I think he wasn't even in the courtroom. So Buckner didn't say anything to her when they reviewed it. So my apologies on that. That was a technical error, and I'm sorry, okay? But yes, his case was dismissed because according to the times that she said and how she described where he was when the screen went private, they looked at all of that. So I know there was questions about whether they was able to record. He wasn't near her. He didn't say anything to her. Wasn't even there when she said that occurred. He had already left. Isn't that amazing? And I know it is what it is, but that's what happened. And I just saw it ended. I was like, holy crap. But it honestly was probably like another minute or two. You're not missing much. So how everybody feel? I know. Is that a shocker or what? I mean, how many people thought that she was telling the truth? Let me see. Yeah, I'm just looking at that. That shocked me when I heard that. I was like, what? So, yeah, because I put a lot of these together. And I think when I processed it out, it was just that little tidbit that must have cut. And, but yeah, case dismissed. Again, and then I don't know if Rob is still in the chat, but he had a case over in Judge Washington's court for something else. I think it was another intimidating, but that one wasn't aired. But that one was dismissed too, and that was like a week or two ago. So sometimes you just don't put them up, especially if they're in court. Some courts just won't show it, but if they're on Zoom, you get to see it. So this is what I'm gonna do. I have the ones from Judge Washington's hearings with him. So I'll do another live tomorrow. I'll make it a little earlier. It won't be this late because we do our late thing on the weekend, but this is the earliest I could get it out tonight. So I'll work on that. And what I may do is the part that you didn't hear, I could put that at the end of it if you want to hear it. Y'all let me know if that's what you want me to do. But I could put it at the end of the Washington's hearing, or maybe I could just I'll do it at the end, because if I do it at the beginning, everybody might not be here yet, and then you might miss it. So I'll get all that together from the parts that you missed. So thank everybody for coming in tonight. I really appreciate it. Oh, did he get? Yeah, he walked out the door when that was over with. He walked out. Matter of fact, he left there he had to go to community corrections to get the tether off. And then he had to go to Judge Washington's court the same day. So I have it. Trish said she hated every minute of it. Trish was saying that she was kind of getting bored with it. This is a long, drawn out, just trying to figure things out. And I don't know why she said what she said or did what she did, but they didn't say anything about her being in contempt or anything like that. It was just over with, and that was the end of it. So, oh, you're welcome, Mad Jack. Like I said, thanks everybody for coming out and hanging out tonight. Cool Clearwater, I'm glad you're doing good. You're welcome. No, don't worry about being late. You can always go back and look at it. I put the notice of this in the community post yesterday so that to give people time, but YouTube's not gonna, sometimes they just don't put the alerts out. That's why I created this thing here. So if you want alerts only for lives and premieres, that's it. And just to let you know, people are texting me on this live thing. It's no response there. So if you leave your email address when you sign up and you have a question through the text, I can email you, but I can't text back on this normally. So there it is right there. You'll just get the live alerts. If you want, you just go to the phone number and all the instructions here. And I think Aqua Queen put it in the chat. But whenever I go live or do a premiere, you got it. Because this thing is efficient and it comes up, and people have been telling me through comments that they get them, and it comes out within 2 minutes of me putting something on. What I try to do is tell you about 10 to 15 minutes early in case you're doing something. Now today I did it 30 minutes early because this is not a night that I normally live stream, so I wanted to give people opportunity to try to get in. So thanks, Aqua Queen. Your eyes is hurting in water. Oh, well, I don't know if it's because you're sleepy or you've been laughing at Mel for the last 30 minutes. Mel, thanks for all the jokes you put out tonight. Good time. And thank everyone once again. Thank you for the subscribers and the members. Everybody special. Y'all have a good evening if you're wherever you are, or some people here in the morning time. But I'll see you tomorrow, and I'll post a time in the community post. I don't want to commit to a time yet. Let me get everything together and make sure I give you that last little 2 minutes of this thing that you missed. All right. So I'll see y'all around.